Let's continue and give you analysis on the outcomes from the Senzo Meyiwa Murder Trial in the North Gauteng High Court. And for more analysis on this, we're now joined by legal expert Nthabiseng Dubazana from Dubazana Attorneys, and she joins us via our telephone line. Nthabiseng, thank you so much once again for your time this evening. Of course, asking you a bit earlier on when it comes to your reaction to the judgment by the North Gauteng High Court, and you said that you are really not shocked.
Yes, I am not shocked based on the manner on which the presiding officer was conducting the trial within the trial, the kinds of interjections and the kinds of comments that were thrown in the mix. I think for me personally, it has been a theme throughout the entire trial in the manner in which the presiding officer tends to act as if they are a prosecutor within the matter and neglecting to be neutral in the matter. Of course, I may be biased in my observation and somebody else may see it in a different way, but I'm not shocked really at the fact that the confession was deducted to be admissible in the main trial.
And what would you say informed the judge's decision to come to that conclusion?
I'm actually not very sure, considering the kinds of questions that were put to the various witnesses for this trial within the trial in terms of how this confession was conducted. The requirements that are set out in Section 217 and Section 218 and also Section 219 of the Criminal Procedure Act are very clear in the manner in which it's supposed to be done. And from what you can gather, one of the accused persons, it was informed, I don't even remember when, but one of the witnesses confirmed that the accused person terminated mandate with his attorney, and therefore when this confession was reduced to writing, he did not understand what had happened because it wasn't explained to him thoroughly. And yet here we are having a confession being admitted into evidence with such commentary or such evidence that has been led. So I suppose with everything that has happened, the presiding officer deems that the requirements have been met, that the accused persons were in their soundness with their senses, they were not forced to make this confession or the pointing out, and as such, the confession can now be admitted in the main trial.
And Nthabiseng, we've seen so many delays when it comes to this specific case, and one would also ask that can the accused actually challenge this outcome, and what grounds do they have should they look at actually challenging the outcomes of today's judgment?
They can challenge it, but it's going to be challenged at the end of the trial because this was a preliminary inquiry. So the main trial is not over and done with. So in other words, it was just a sidestep. Maybe if I put it this way, the way in which the witnesses in the state case right now, because the state case is still open, when witnesses come to the box and they're not being cross-examined, the defense attorneys do what we call a laying of basis when they want to use the statements that were made by the witnesses to contradict whatever the witness has been saying in court on that particular day. So instead of doing it the way in which defense attorneys do it by laying basis for about 5 minutes and then continuing with cross-examination, for the accused person, it has to go through the stringent requirements that we have seen in the past 5 months. And if the court accepts that quote-unquote the laying of basis for that confession to be admitted, then the tables can be turned. In other words, when the accused persons now go into the box and give their evidence, their confession is going to be used against them also in cross-examination by the state.
And what does this mean also in a nutshell, especially now for the accused? This is evidence that they don't want to see in court.
Well, at this stage, there's nothing much they can do. It's just now the witnesses that were giving evidence in the manner in which the statement or the confession was made are now going to give us the merits of the statement, which are going to relate to the actual case that we need to be dealing with. So at this stage, the only thing that the accused persons can do is sit and watch. We'll only know the probative value or the weight in which the court is going to give these statements at the end of the trial when judgment is handed down. And if the judge decides that the confessions have a heavy or a strong weight, or what we call probative value, then in that instance, the defense attorneys will then have the opportunity, once judgment has been handed down and sentenced, then they can make an appeal or a review application at the end.
And lastly, for the trial, which is now set to get underway, with this the evidence, what would it mean then for the actual trial going forward?
So now, hopefully, we're not going to encounter any more detours going forward. So now it's just a matter of basically continuing where we stopped 5 months ago. If that witness, I don't even remember if that witness was done giving evidence at the time. If that witness was done, then we continue to the next witness that the state is going to call, particularly the witnesses that are going to now confirm the contents of those confessions. And then obviously we continue in the same manner wherein the defense attorneys will then cross-examine the witnesses. But the thing that we need to be mindful of is that the evidence that was adduced within the trial is not going to be used in the main trial. So the defense attorneys can't say, no, but wait, in the trial within a trial you said, but now you are saying this. So it will be as if the trial within a trial never really happened. We are now focusing on the merits of the matter.
All right, Nthabiseng, thank you so much for your contribution. That is Nthabiseng Dubazana, legal expert from Dubazana Attorneys.